This case is coming up today for judgment. And the judgment of this honorable court is ready, and I'm going to read the judgment of this court. Counsel, can you hear me?
As the court pleases.
Very well. And
as the court pleases, my noble lord. We can hear my noble lord.
Very well. What I want to do is that in the course of reading this judgment, I will read the introductory part of it, and then I will skip some areas that I feel that they are not necessary for me to read them, though they are captured very well in the judgment, so that we can save time.
As the court pleases, my lord.
Now, this is the
As
judgment.
the court pleases, my lord.
This action was commenced by a general form of complaint dated and filed on the 19th July 2024, wherein the claimant sought from this court against the defendant the following reliefs. One, a declaration from this honorable court stating that the actions and inactions of the defendant significantly and negatively impacted the claimant's working conditions, to the extent that it was unreasonable to expect the claimant to continue working for the defendant. Two, a declaration that due to the hostile and humiliating work environment, the claimant's purported resignation should be considered a constructive dismissal by the defendant and a wrongful dismissal. Three, a declaration that the acts of the defendant against the claimant during his employment with the defendant constituted acts of unfair labor practice. Four, an order of this honorable court directing the defendant to pay the claimant the sum of 20 million naira as general damages for wrongful dismissal from the defendant's employment. Five, an order of this honorable court directing the defendant to pay the sum of 200 million naira to the claimant as aggravated and exemplary damages against the defendant for humiliating and degrading the claimant in the eyes of his subordinates and inhumane treatment, intimidation, and harassment meted out to the claimant by the Nigerian police force at the invitation of the defendant. Six, an order of this honorable court directing the defendant to release to the claimant the original title documents of 2008 Toyota RAV4 silver color with registration number BDG811HW and chassis number JTM BD32V9860799104, having received the balance of the said vehicle in lump sum. Seven, the sum of 200 million naira as cost of this action. In response, filed a memorandum of appearance and statement of defense dated and filed on the 5th day of August 2024, containing the counterclaim of the defendant, and the claimant filed a reply to the statement of defense and defense to the counterclaim on the 16th day of August 2024. The case of the claimant, briefly put, is that the claimant maintains in his affirmance that he was constructively discharged or dismissed from the employment by the defendant when he was unjustly demoted without any disciplinary action prior to his demotion, and he was issued warning letters after his demotion. Even he was appreciated for performing excellently in discharge of his duty a month prior to his demotion. Claimant stated that his salary was reduced and he was subjected to unfair labor practice, and further to that, he was humiliated, harassed, and intimidated due to his demotion, and that despite the fact that he was constructively dismissed, it became impossible for him to continue the payment of the car loan by virtue of his salary reduction. He obtained a loan from bank and paid the balance of the car loan to the defendant's account, which the said money is still in the custody of the defendant till today. Claimant avers further that the original documents of the car have not been handed over to him, and the defendant has not perfected change of ownership despite that the claimant had defrayed the balance sum. The claimant stated that the defendant invited the police to ensure that the vehicle is retrieved from him despite the full payment. The case of the defendant avers that the claimant was employed as an experiment farm technical manager of sales department in November 2018, and his duties were not fixed. Defendant stated that it considered purchasing vehicles as part of employment incentives. Purchased vehicles for senior staff in the sales department, and the class of vehicles were based on their cadre in the department, which the claimant was newly promoted as regional manager was eligible. Defendant stated further that the claimant was demoted for poor performance, negligence in line of duty, failure to serve customers, and struggle to meet the normal requirements in his role as a regional manager of sales department, and there was no hostility or maltreatment as alleged by the claimant towards him. The claimant was issued a warning letter prior to his demotion to that effect. Defendant contended that the vehicle incentives were not availed to the staff within the new position of the claimant, but opted to leave the vehicle in possession of the claimant, as it would assist his daily activities, reduce embarrassment, and pending a resolution to renegotiate his vehicle leave refinancing. Counsel stated that it is stated that prior to the claimant making the monetary transfer, he had stopped reporting to work since 29th May 2024 and absconded with the vehicle, and thereafter, on his own volition, calculated figures and made the bank transfer to the defendant company, notifying them of the transferred stamp for the vehicle. We transferred some of the vehicle. The defendant company transferred the money back to the claimant. Defendant averred that they would not have obliged the request of change of ownership documents of the vehicle because the claimant had violated both the lease vehicle agreement and vehicle management systems of marketing managers, particularly clause 8.1.1 and 8.1.2 of the former and Article 9, sub 2 and 3 of the latter. The matter was then transferred to the police after the defendant petitioned the claimant. Counterclaim, the defendant filed a counterclaim on the 6th day of August 2024 and stated that the claimant defendant to the counterclaim absconded from work with the vehicle given to him under a lease vehicle agreement and vehicle management systems of marketing managers. It is contended that the claimant defendant to the claimant it is contended that the claimant / defendant to the counterclaim violated clause 8.1.1 and 8.1.2 of the vehicle lease agreement and article 9 sub 2 and 3 of the vehicle management systems of marketing managers. Counsel further, it is further contended that the claimant / defendant to the counterclaim had agreed in the agreement that in the event of resignation or termination of employment, the vehicle would be returned to the company as it is the practice of the company wherein other staff had returned their vehicle to the company after resignation. It is further contended that the claimant defendant to the counterclaim was invited severally on how to resolve the issue, but it was all to no avail. Defendant / counterclaimant, defendant / claimant to the counterclaim had made the counterclaimant incur expenses in the recovery of the vehicle and caused reputational damages to the company, whereof the claimant, whereof the counterclaimant claims as follows. 1, an order of specific performance by this honorable court compelling the claimant / defendant to the counterclaim to return the vehicle to the defendant counterclaimant. 2, an order of this honorable court directing the claimant defendant to pay a sum of 300 million naira as reputational damages suffered by the company during the course of trying to retrieve their vehicle. 3, an order of this honorable court directing the claimant defendant to pay a sum of 50 million naira as general damages suffered by the company in this matter. 4, an order of this honorable court directing the claimant / defendant to pay a sum of 10 million naira for expenses incurred trying to retrieve the vehicle. And 5, a sum of 5 million naira as cost of this suit. Claimant's reply to the defendant's statement of defense is also captured here. Claimant filed his reply to the defendant's statement of defense on 16th August 2024 and stated that his demotion was not as a result of poor performance, but unfair labor practice of the defendant to dismiss all old staff as they do not want to pay their salary, but wanted new entrants. Claimant further stated that he was awarded best manager for achieving 102% of his target in February 2024 and second best in March 2024. Claimant averred that he was demoted to sales representative, but he still achieved his target and that he was under a pay salary of 44,618 naira. Claimant maintained that the warning letter had nothing to do with his performance and that the warning letters issued on the 17th and 30th days of May 2024 were to frustrate him out of employment as there was no evidence of negligence of duty. Claimant contended that there was maltreatment in the company as he was forced to report to his junior team member, claimant's father contended that he was still in the employment of the defendant before 29th May 2024, and that the amount to be paid for the car was certain, as the defendant was already deducting the amount from his salary before he paid the lump sum. Claimant maintained that a criminal petition of theft was filed against him to the police by the defendant for his unknown whereabouts when the defendant has his house address. Claimant's defense to the defendant's counterclaim. Claimant's defense to the defendant's counterclaim is dated and filed on the 16th of August 2024, wherein claimant stated that he denies each and every material allegation of facts contained in the defendant's counterclaim. The counterclaim, defendant to the counterclaim, the claimant / defendant to the counterclaim stated that they adopt all their affirmations in reply to the defendant's statement of defense in this defense to the counterclaim, and that the defendant's counterclaim is devoid of merit and amounts to gold digging. Claimant urged the court to dismiss the defendant's counterclaim with substantial cost. Trial commenced on the 16th of October 2025, wherein CW1 adopted his written statement on oath, deposed to on the 19th of July 2024, and tendered the following documents in evidence, which were admitted as exhibits. 1 offer of employment dated the 1st day of November 2018, which is marked as Exhibit C1. 2 exhibit vehicle management system of marketing managers is marked as Exhibit C2. Vehicle lease agreement dated 30th January 2023 is marked as Exhibit C3. WhatsApp screenshot of the award is Exhibit C4. Credit alert notification screenshot is Exhibit C5. Screenshot of chart credit alert received on the 5th day of June 2024 is Exhibit C6. Later dated 10th June 2024 is marked as Exhibit C7. Transfer received dated 13th June 2024 is Exhibit C8. And professional fee receipt issued by the solicitor for cost of his action is Exhibit C9. CW1 was thereafter cross-examined by learned counsel to the defendant, and there was no re-examination. The case of the claimant was then closed on the application of counsel. The defendant opened their defense on the 11th day of December 2025, at which Augustine Salim gave evidence as DW1. Consequent upon adoption of his written deposition, he tendered the following documents in evidence, which were admitted and marked as exhibits. 1 offer of employment, which is marked as Exhibit D1. Vehicle lease agreement marked as Exhibit D2. Vehicle management system of marketing managers, Exhibit D3. Petition against the claimant dated 28th June 2024, Exhibit C4, and warning letter to the claimant dated 17th May 2024, Exhibit D5. Whereas later from Legal In dated 3rd June 2024 is Exhibit D6, warning letter of the 30th June 2024 to the claimant is Exhibit D7, payment advice of Zenith Bank dated 6th day of June 2024 is Exhibit D8. DW1 was then cross-examined by learned counsel for the claimant and re-examined by defendant's counsel. The case of the defendant was then closed following the application of counsel. Defendant's final written address
I will skip that one. I have captured everything. It's there. You read it when you get the copy of the judgment. Consequent upon that, then the claimant's final written address is also captured here. Then defendant's reply on points of law to the claimant's final written address is as well captured. I'll proceed to read the decision of this honorable court in order to save time, as I indicated earlier. I have carefully read through the processes filed and also listened to the evidence as well as the arguments canvassed on the formulated issues by counsel on both sides. The issue that will be all-encompassing in determining this case, in my view, is simple. This court adopts the issues distilled by the parties and resolves them as follows. 1, whether the claimant has established that he was constructively dismissed. 2, whether the claimant has proved unfair labor practice. 3, whether the claimant is entitled to ownership and the release of title documents of the vehicle. 4, whether the parties are entitled to the relief sought, including the counterclaim. Before I go into the argument, it is pertinent to resolve the contention of counsel for the claimant at the preliminary part of his adumbration, when he argued that he has observed that the reply address filed by the defense counsel contains in some paragraph breaches of the rules of reply because, according to counsel, some paragraphs offend the purpose of reply on points of law. Counsel pointed out at paragraphs 2.3.2, 2.3.3, and 2.3.4 of the reply address to the claimant's issue number 3. Counsel cited the Supreme Court case of Abeokuta against Agbaje, citation provided, where counsel stated that the Supreme Court held that reply brief, which is in paramateria with reply on points of law, is not to repair kit for a party to re-argue his case. More so, in the case of Tiddo Securities Limited against Ahmed, citation provided, counsel urged this honorable court to discountenance those paragraphs of the reply filed by the counsel for the defendant on that note. Without any prolongation of this issue, it becomes very easy for me to resolve this preliminary issue contended by the claimant's counsel, as it is a known issue because the argument of the said counsel is vague and uncertain, since counsel did not demonstrate how the reply filed could amount to defendant re-arguing his case. It is clear that the claimant's counsel did not assist this court in his contention. Same is misleading, and I discountenance the submission of counsel for the claimant in this respect. The law is settled that constructive dismissal, as it is raised by the claimant, occurs where an employer commits a fundamental breach of the contract of employment, which makes it impossible to unreasonable for the employee to continue in the employment. Now, this court has dealt with the concept of constructive dismissal in a number of cases. See Ms. Abeokuta against Standard Alliance Life Assurance Company Limited. I will give the citation as 2014-47 Nigerian Labor Law Report, Part 158, page 531. It's a decision of this honorable court. Mr. Patrick Obiara, Nodilim against United Bank for Africa, PLC, unreported suit number NICN/LA/353/2012. Mrs. Angela Awuse Atanda against Abe Building Society, unreported suit number NICN/ABJ/211/2019, and Joseph Okafo against Nigeria Aviation Handling Company Limited PLC, and reported suit number NICN/LS/29/2016. In Ms. Abeokuta against Standard Alliance Life Assurance Company Limited, Supra, it was held thus, and I quote, globally and in labor/employment law, constructive dismissal, also referred to as constructive discharge, occurs when an employee resigns because his or her employer's behavior has become intolerable and or heinous or made life difficult, that the employee has no choice but to resign. Given that the resignation was not truly voluntary, it is in effect a termination. In an alternative sense, constructive dismissal or constructive discharge is a situation where an employer creates such working conditions or so changes the terms of employment that the affected employee has little or no choice but to resign. Thus, where an employer makes life extremely difficult for an employee to attempt to have the employee resign, rather than outright firing the employer is trying to create a constructive discharge. The exact legal consequences differ from country to country, but generally, a constructive dismissal leads to the employee's obligations ending and the employee acquiring the right to seek legal compensation against the employer. The employee may resign over a single serious incident or over a pattern of incidents. Generally, the employee must have resigned soon after the incident. See generally Western Excavating against Sharp. Citation, this is a foreign decision. Citation is 1978, one All English Report, page 713, and Oladosu Oguniyi's Nigerian Labor and Employment Law in Perspective, Folio Publishers Limited, Ikeja 2004, second edition, at pages 466 to 464, end of quote. For the claimant to succeed in a case of constructive dismissal, he must bear the burden to show that he resigns soon after the incidents. He is complaining about, as suggested in the case of Ms. Abeokuta against Standard Alliance Life Assurance Company Limited, Supra. He must also prove, as stated in Western Excavating against Sharp's Supra, that there is a repudiatory breach, either actual or anticipatory, on the part of the employer, which must be sufficiently serious to justify the employee resigning. The employee must resign in response to the breach and must not delay too long in acting on the breach. It is the claimant's case that he was constructively dismissed from the employment by the defendant when he was unjustly demoted without any disciplinary action prior to his demotion and was issued warning letters after his demotion, even when he was appreciated for performing excellently in discharge of his duty a month prior to his demotion. Claimant stated that his salary was reduced and he was subjected to unfair labor practice. He was humiliated, harassed, and intimidated due to his demotion, despite the fact that he was constructively dismissed and it is impossible to continue the payment of the car loan by virtue of his salary reduction. He obtained a loan from bank and paid the balance of the car loan to the defendant's account, which he further stated the said money is in the custody of the defendant till today. Claimant contended that the original documents of the car have not been handed over to him, and the defendant has not perfected change of ownership despite that the claimant had defrayed the balance sum. The claimant stated that the defendant invited the police to ensure that the vehicle is retrieved from him despite the full payment thereof. In the present case, the claimant tendered his offer of employment, which is Exhibit C1. However, no provision was brought to the attention of this honorable court prohibiting demotion or reassignment of duties that is captured in the said exhibit. It is tried that the master-servant employment, it is tried that in a master-servant employment, an employer retains managerial prerogative to restructure, reassign, or discipline an employee, provided such action does not violate express contractual terms. The claimant alleged demotion and reduction of salary from 500,000 naira to 44,000 naira. But in this context, there is no cogent documentary evidence showing the alleged salary structure before and after demotion beyond these assertions. Warning letters were tendered by the defendant. The claimant continued in service of the defendant after the alleged demotion. There was no formal protest or complaint shown in respect or against. Constructive dismissal requires proof of a fundamental breach. Mere dissatisfaction, strained relationship, or embarrassment does not suffice. This court finds that the claimant has failed to establish that the defendant committed a fundamental breach that rendered continued employment impossible. And I so hold. Accordingly, reliefs seeking declaration of constructive dismissal and wrongful dismissal must fail, and so have failed. Same are hereby refused. Regarding unfair labor practice asserted by the claimant, I took resort to and by virtue of Section 254C1F of the 1999 Constitution of the Federal Republic of Nigeria, as amended, this court has jurisdiction over unfair labor practices. However, allegations of humiliation, intimidation, and hostile work environment must be proved by credible evidence. No independent evidence was laid to substantiate harassment or humiliation. The mere issuance of warning letters or reported structural adjustment is normal routine and does not automatically amount to unfair labor practice. The criminal petition to the police arose from dispute over possession of the vehicle. No evidence was laid showing malicious prosecution within the context of the law or abuse of process. This court finds that unfair labor practice was not proved. The relief for 200 million naira aggravated and exemplary damages accordingly fails, and it is accordingly refused. On the claim of vehicle ownership, the vehicle in question was subject to a vehicle lease agreement as captured by Exhibit C3 and Exhibit D2. The law on hire purchase and lease agreements is settled because ownership remains with the lessor until full payment and compliance with contractual conditions are met. Furthermore, in a hire purchase transaction, it is elementary that the owner of goods/vehicle at common law has the right to seize the goods/vehicle, which is the subject matter of the hire purchase. from the hirer. In the event that the hirer defaulted in payment, granted the Hire Purchase Act 1965 has whittled down the power of the owner in hire purchase to seize the goods/vehicle from the hirer in cases of default. The law as it is presently is that the owner cannot take possession of the vehicle whereby the hirer has paid up to 3/5 of the purchase price except by order of court. For the avoidance of doubt, see Section 9, Subsection 1 of the Hire Purchase Act 1965 Act, which provides where goods have been let down, where goods have been let under a hire purchase agreement and the relevant proportion of the hire purchase price has been paid, whether in pursuance of a judgment or otherwise, or tendered by or on behalf of the hirer or any guarantor, the owner shall not enforce any right to recover possession of the goods from the hirer, otherwise than by action and except as provided by subsection 5 of this section. On what amounts to payment of relevant proportion of the hire purchase price, Section 9, Sub 4 of the Act provides that the hirer must have paid A, in the case of goods other than motor vehicle, 1/2 of the hire purchase price. B, in the case of motor vehicle, 3/5 of the hire purchase price. See also the decision of the Supreme Court on the effect of payment of 3/5 in Civil Design Construction Nigeria Limited against SCOA Nigeria Limited. Citation capture. The law is that in the event that the hirer has not paid up to 3/5 of the purchase price, the Act empowers the owner to take possession pending the institution of an action. See Section 9, Subsection 5 of the Hire Purchase Act 1965, which I quote. In the application of the provisions of this section, a motor vehicle is where 3 or more installments of the hire purchase price of a motor vehicle under the agreement are due and unpaid. The owner may remove the motor vehicle to any premises under his control for the purpose of protecting it from damage or depreciation and retain it there pending the determination of any action. And the owner shall be liable to the hirer for any damage or loss which may be caused by the removal. Clause 8.1.1 and Clause 8.1.2 of Exhibit C2 states, and I quote, if the lessee's contract of employment is terminated during the lease period, the vehicle shall hand to the lessor. The lease payment funds shall be handled in accordance with the vehicle management system of marketing managers of New Hope Agriculture and Technology Nigeria Limited. 8.1.2 provides if lessee engages in the following acts, the lessor has the right to terminate the contract and take back the vehicle. The lease payment funds of the vehicle shall be handled in accordance with the vehicle management system of marketing managers of New Hope Agri and Tech Nigeria Limited. End of quote. Further, it provides A, false information, B, arrears of repayment or other expenses. C, resale, mortgage, pledge, lend, pawn, and sublet vehicle or evidence that the risk of same exists. D, there is evidence that the lessee uses the leased vehicle to engage in illegal and criminal activities. E, loss and damage to the vehicle caused by failure to use the vehicle in compliance with performance operating procedures bear the loss of the insurance company's refusal to indemnify. F, unauthorized modification, replacement, addition of other things, etc., to repair the damage caused to the original set of the vehicle. G, failure to allow the lessor conduct vehicle inspection or maintenance on time. H, the actions of the lessee cause the vehicle to be seized by a third party. And I, in case of violation of traffic safety regulations, the penalty shall be accepted within 5 days of being notified. If the punishment is refused, the driver registered in the contract will be submitted to the police station as the person responsible for the violation. Article 9 of Exhibit C3 states, anyone who meets the following matters within the period of deduction of the instrumental payment be dealt as follows. 1, if the user is transferred or fails to apply the installment program, suspended or dismissed from management, cancel the using right and cancel the installment program, the vehicle shall be returned to the company, and the deducted installment shall be withheld to article the company. The amount as compensation for vehicle depreciation and funds interest will not be refunded, or the vehicle's remaining money will be paid to the company in one lump sum, and the ownership of the car will be changed to the user. 2, when the user resigns from the company, cancel the using right and cancel the installment program, the vehicle shall be returned to the company, and the deductible amount of the installment that has been withheld to the company shall not be refunded as compensation for depreciation and funds interest of the vehicle. 3, when the user is fired, etc., cancel the using right and cancel the installment program. The vehicle shall be returned to the company, and the deductible amount of the deductible shall be refunded another half as a compensation for depreciation and funds interest of the vehicle shall not be refunded. The claimant contended that he paid 3,208,380 as balance. The defendant tendered evidence that the payment was refunded as seen in Exhibit D8. There is no evidence before this court of acceptance of full settlement by the defendant or issuance of transfer documents. Under a hire purchase or lease arrangement, unilateral computation and payment by a hirer does not automatically vest title unless accepted and conditions fulfilled. Furthermore, The defendant retained registration and issuance and insurance documents in its name. This court finds that the claimant has not proved that legal title of the vehicle passed to him. Accordingly, the claim for release of original title documents has no basis as such. It has failed. On general damages for wrongful dismissal are usually measured by what the employee would have earned during notice period in ordinary master-servant employment. The law is well settled that general damages cover losses which are not capable of exact quantification. They do not need to be specifically pleaded, although some evidence of the damage is required. See AB against Central Bank of Nigeria citation captured. The law will presume general damages to be the direct natural and probable or natural or probable consequences of the act complained of, but the quantification thereof is at the discretion of the court. See Jebu Ode local government against Udedeji Balogun and Company Limited citation captured. Esigbe against Agolo citation provided, and Badmus against Abigunde citation captured. Mosu Ajibotusu against Ronald's Construction Company Limited citation as well captured. The law implies where not specifically pleaded. This includes compensation for pain and suffering and the like. And if the injuries suffered are such as to lead to continuing or permanent disability, compensation for the loss of earning in the future would be considered. See Obasui against Business Ventures Limited citation captured. As far as the facts of this case are concerned and taking a close look at the circumstances, there is no evidence of damages occurring to the claimants. In view of this, the court having granted the claimant's claim as terminal benefit, it will amount to double compensation to grant general damages to the claimants. This relief fails, and same is hereby refused and dismissed. Since wrongful or constructive dismissal has not been established, the claim for 20 million naira general damages also fails. Exemplary damages are not awarded in ordinary employment disputes as in this instant case, and there is absence of exceptional circumstances shown or proved by the claimant. This suit lacks merit and on the counterclaim lacks merit. And on the counterclaim, the counterclaimant alleged that the claimant absconded with a vehicle given to him under a vehicle lease agreement, and that under clause 8.1.1 and 8.1.2 of the agreement, the vehicle must be returned upon resignation or termination of employment. It is tried law that he who asserts must prove. The burden lies on the counterclaimant to establish the existence of the agreement, the relevant clause requiring return of the vehicle, and that the claimant retain the vehicle in breach of the agreement. See clause 8.1.1 and 8.1.2 of the vehicle lease agreement, being exhibit C2 and exhibit C9 of the vehicle management system of marketing managers as reproduced above. Where a contract clearly provides that the source of the light is off. Where a contract clearly provides that property issued to an employee must be returned upon cessation of employment, the court may grant specific performance or an order for delivery of this property. Having found that the ownership remains with the defendant under the lease agreement and that title has not passed to the claimant, the defendant's proprietary right subsists and worthy protection. Accordingly, the counterclaim succeeds to the extent that the claimant shall forthwith return the 2008 Toyota RAV4 with registration number PDG 811HW to the defendant. An order is hereby granted directing the claimant defendant to the counterclaim to return the vehicle belonging to the defendant counterclaimant forthwith within 14 days. The counterclaimant claims of 300 million naira as reputational damages allegedly suffered while attempting to recover the vehicle. Reputational damages are essentially damages for defamation or injury to reputation. Such damages must be specifically pleaded and strictly proved. There must be evidence to show how the company's reputation was actually damaged. Mere stating that the company suffered reputational harm is insufficient. Therefore, in the absence of cogent reason and or evidence, such as loss of evidence, loss of business, public embarrassment, publication affecting reputation, this claim is baseless and so it fails. In the claim for 50 million naira general damages, it is the law that general damages may be awarded where the court finds that a breach of contract occurred. However, where the primary relief is recovery of property and the claimant has not demonstrated substantial reason or loss beyond the detention of the vehicle, the courts are generally reluctant to award excessive general damages. The court must also ensure damages are reasonable and not punitive. The claim for 50 million naira general damages is excessive and not justified. This relief fails as well. In the claim for 10 million naira recovery expenses, special damages such as expenses incurred must be specifically pleaded, strictly proved with receipts or documentary evidence. If no receipts, invoices, or documentary proof were tendered, the claim cannot succeed. The claim for 10 million naira recovery expenses fails for lack of strict proof. On the course of action, costs are awarded at the discretion of the court, considering that the counterclaimant only partially succeeded. The court may award moderate costs. Costs follows event under Order 55 of the Rules of this Honorable Court 2017. However, this court exercises discretion judicially. Cost of 100,000 naira is awarded in favor of the defendant counterclaimant against the claimant defendant to the counterclaim. Accordingly, the claimant's claims for declarations of constructive dismissal, wrongful dismissal, and unfair labor practice are hereby dismissed. The claims for 20 million naira general damages and 200 million naira aggravated and exemplary damages are as well refused. The claim for release of original title documents of 2008 Toyota RAV4 is also refused. Therefore, all the reliefs of the claimant failed. The defendant's counterclaim succeeds only in part, as the claimant is hereby ordered to return to the defendant the vehicle within 14 days. All in all, cost of 100,000 naira is awarded in favor of the defendant. This is the judgment of this court, and the judgment is accordingly entered.
As the court pleases. We are very much obliged, my noble lord.
As the court pleases, my lord, we sincerely appreciate the well-considered ruling of the honorable courts, and we thank the court for its time and its consideration.
Very well. Yes, what the next case?
Case number 998/11/2024. Between Mr. Abeokuta and Abeokuta against Yelwa Agriculture and Technology Nigeria Limited. Our parties are absent.
Announce your appearances.
May it please, my noble lord, W.A. Bello appears for the claimants.
Yes.
Respectful my lord, I.P. Arinze. My appearance is for the defendant.
The case is for judgment, and the judgment of this court is ready. And let me just proceed with the judgment of the court. In the same pattern as I have indicated in the earlier case, which judgment had just been delivered. However, looking at the nature of this case, it is not quite different in materials and in the application of the law with the earlier case, which I have just given judgment in. So I will as well just look at read the introductory part of it, and then read the conclusion part of the judgment. This case is being handled in the same way by the same counsel. Just let me say that it was at only the point of reading through the processes in this case, I realized that this case is in all fours the same with suit number NICN/AB/10/2024, which I have just delivered my judgment in it. So I want counsel to take note and to save the time of this honorable court. The judgment. By way of general form of complaint, along with all necessary processes dated 18th July 2024, but filed on the 19th of July 2024, this suit against the claimant took out this suit against the defendant seeking for the following reliefs. In fact, the reliefs are one and the same thing with the previous ones I've just read. They are 7 in number, and they are all asking for almost the same thing. So I will skip that one. Then the claimant's case is here, almost in the same direction, the same content and pattern. The defendant's case as well is captured. Then the trial commenced on the 16th of October 2025. wherein CW1 adopted his written statement on oath, deposed 2 on the 19th of July 2024 and tendered the following documents in evidence, which were admitted in evidence and marked as Exhibit C1 to C7. C1, upon conclusion of the evidence in chief, was cross-examined by the defendant's counsel, and in the absence of re-examination, claimant's counsel, claimant counsel's case was closed. The claimant's case was closed on the application of the counsel. On 11th of December 2025, the defendant opened and closed his case with Salim Augustine, who testified as DW1, through whom Exhibit D1 to D4 were admitted in evidence. The witness was cross-examined, and there being no re-examination, defendant's case was closed. On 29th January 2026, counsel for the parties adopted their respective final written addresses, and the case was adjourned for judgment, hence this judgment. Defendant filed their final written address on the 2nd day of January 2026, wherein counsel submitted 2 issues for determination as follows. 1, whether having regard to the pleadings and evidence adduced before this honorable court, the claimant has proved the allegations of constructive dismissal so as to entitle him to the relief sought, and 2, whether having regard to the pleadings and the evidence before this honorable court, the claimant has established that the legal ownership and title to the vehicle, a 2005 Toyota Highlander with registration number BDG 522HW and chassis number JIT EEP 21A550112-106 passed to him under the vehicle lease agreement. Arguments were canvassed on the basis of these 2 issues raised by the defendant. Is captured here. I will skip it. Then claimant's final written address is contained, and I captured it here. There are 4 in number. Claimant final written address is dated the 15th day of January 2026, wherein counsel raised the following issues for determination, and there are 4 in number. They are here captured. I will skip it. His arguments based on the issues raised are herein captured. I will skip it. Then defendants apply on points of law to the claimant's final written address is as well captured here. Then the decision of the court. The decision of this honorable court, like I said, is based on issues formulated in the following way. 1, whether the claimant has established that he was constructively dismissed. 2, whether the claimant has proved unfair labor practice. 3, whether the claimant is entitled to ownership and release of title documents of the vehicle. And 4, whether the parties are entitled to the relief sought, including the counterclaim. In fact, these reliefs are one and the same thing with the previous judgment I had just delivered, and the materials are, as it is stated here, are the same thing. I will skip all and I will move straight to the conclusion of the judgment. At the time you the copy of the judgment, what is contained there, all the authorities are one and the same thing. In conclusion, accordingly, the claimant's counsel and the claimant's claims for declarations of constructive dismissal, wrongful dismissal, and unfair labor practice are hereby dismissed. The claimant's claims for 20 million naira general damages and 200 million naira aggravated and exemplary damages are refused. The claim for release of original title documents of the 2005 Toyota Highlander with registration number BDG 522HW and chassis number JTEEP 21A550112-106 is refused. Therefore, all reliefs of the claimant failed. The defendant's counterclaim succeeds only in part as to the claimant is hereby ordered to return to the defendant the vehicle within 14 days. Cost of 100,000 naira is awarded in favor of the defendant.
As the court
Judgment is
pleases.
accordingly entered.
As the court pleases.
As the court pleases, we are very much obliged to the judgment of my noble lord.
Very well.
Lord, we appreciate the well-considered ruling of the Honorable Courts, and we pray the Lord continues to give the courts more and more wisdom and strength, even as he continues in the bench, and we pray for greater appointments and promotion. May it please, my noble lord.
Thank you. The copies of this judgment will be available for you, counsel, and the parties from the register of this honorable court upon all them being certified. So, in the absence of anything, we can now leave the meeting and the court will rise.
Court.
The one is completely.
That is the law.
It is the law. That is the law. He came with,